Okay, welcome. So I'm delighted you're here today for today's Milbank Tweed Forum. So we have three really distinguished guests on our panel, and I know we'll have a great discussion about the Supreme Court and the battle over the federal regulatory reach. As many of you know, the fate of some of our most important regulatory programs often ends up right before the Supreme Court. Today's event is organized by the Institute for Policy Integrity here at the law school, which I direct. And before I introduce the guests, I'll just give you a little sense of what we do and how we connect to the topic today. So policy integrity is basically a combination between a think tank and advocacy organization. And in terms of what we'll talk about today, we've been involved as amici in the Supreme Court and the main Supreme Court and DC Circuit cases on environmental regulation and the control of greenhouse gases. We did 2 amicus briefs in the 2 cases the Supreme Court decided last term. We're doing one for this term's a big environmental case, and same on the DC Circuit. And a lot of this work is done by students in our regulatory policy clinic, whom we work with very closely. And it was really in connection with this work that my path started intersecting with 2 of the panelists, with Sean Donohue and Peter Keisler. So let me tell you why putting this panel together made me feel really good about being a lawyer in this country. So, for starters, Sean and Peter are on opposite sides of some of the most controversial cases in this country in the areas that I care about, which are environmental regulation and the control of greenhouse gases. And the sort of atmosphere of civility and admiration that exists among all 3 panelists in this group is really is really heartwarming, because as you sort of follow the discussions in the political sphere, you don't often see it in the way you see it here. So without further ado, I'll go to the introductions, and then we'll get started with our talk. So I'll do this alphabetically by last name. Sean Donohue spent 4 years in the Justice Department's Environment and Natural Resource Division before he established his own private practice in 2002. And these days, generally represents environmental organizations in major appellate cases. He argued a very important Supreme Court case in the environmental area. For those of you who follow this, EDF versus Duke Energy, which stands for the proposition that the same words as applied in different sections of the statute can be given different meanings by administrative agencies, and the court upheld sided with Sean. Before all of this, Sean was a law student at the University of Chicago Law School, and then was a law clerk to then Judge Ruth Bader Ginsburg on the DC Circuit and Justice John Paul Stevens. Caitlin Halligan is a litigation partner in the New York office of Gibson, Dunn & Crutcher. She's a member of the Appellate and Constitutional Practice Group. Immediately before that, she served as general counsel to the New York County DA's office, where she oversaw more than 500 lawyers. And previously, she had been the Solicitor General of the state of New York from 2001 to 2007. This is a position that represents the state of New York in litigation before the U.S. Supreme Court and other appellate courts. She supervised a team of 45 lawyers and argued many important regulatory cases. These days, she teaches the Columbia version of our legislation and regulatory state course, for which we forgive her.
I couldn't get a gig here, so I had to go uptown.
Caitlin is a graduate of Georgetown Law School and was a law clerk for Judge Wald on the DC Circuit, and then for Justice Breyer on the Supreme Court. Peter Keisler currently co-chairs Cillian Austin Supreme Court and Appellate Practice Group, and has argued a wide range of federal constitutionally, statutory, and administrative cases before the Supreme Court and other federal courts. In connection with cases I was telling you about, he has been the lead lawyer for industry trade associations in the most significant environmental and climate change cases. He spent many years in the Justice Department, first as Assistant Attorney General for the Civil Division, and then in 2007, between September and November of 2007, as Acting Attorney General of the United States. He's a graduate of the Yale Law School, and he clerked for Judge Robert Bork on the DC Circuit, and then for Justice Anthony Kennedy. Peter and I were friends in law school, and it's great to welcome him here as well. And so let me say one word, because it really affected this law school significantly. Peter did something very courageous when he was in the Justice Department as head of the Civil Division, which was to speak against the politicization of hiring in the Justice Department Honors Program under his predecessor, Attorney General Alberto Gonzalez. This is something we felt very vividly in the law school, because for a while our students basically who had done very well in the Justice Department Honors Program stopped getting any jobs at all, I think because we read a liberal school. And Peter, as a high-level member of the administration, spoke against this, and when he became Acting Attorney General, this practice ended, for which many of our graduates are very grateful. So I wanted to thank you publicly for that. So we're very lucky to have all three panelists today. I thought what I would do is ask them a number of questions. They can decide the order in which they address them. Each doesn't have to address every question, and then after a while we'll sort of open things up to questions. So the cases that you're all involved in, to a large extent, are cases of statutory interpretation. And I'd like to have us start discussing whether we can tell anything about the approach of the Roberts Court to statute interpretation in regulatory cases.
I'll throw something out and set a low bar. I mean, one thing I would say about the court before, I mean, when we follow the Supreme Court in the press, and when we think about the cases that everybody cares about, the Affordable Care Act case this year, big cases about abortion, voting rights that tend to get play, we focus on difference. There's a tremendous amount of continuity, and of course, as many people know, that the court last term decided more cases unanimously than has been the case in many, many decades, 2/3 of the cases, so despite these differences. And so I would say in statutory construction, perhaps even more than in constitutional law, there's a lot of stability and familiarity to the kind of principles that draw the court together. And I think this court in general is a court across the board, across the spectrum, that tends to like sort of plain meaning textualist arguments and arguments that are more ethereal and purpose driven, and certainly legislative history are less so. So I think, you know, as an advocate in the court, you probably your first resort is to try to get your statutory construction case in that sort of 2/3 that are going to go unanimously your way. And I think there are some tendencies that we see, like with legislative history. It looked like maybe the court, led by Justice Scalia, was going to really kind of push it out, and I think that hasn't happened, and people still cite it, and even Justice Scalia seems to be a little less aggressive about protesting. But the first point I would make is you know, I think there's probably more continuity than innovation on this court in statutory cases.
I think that's right, and I think that there's real consensus that the place you look first is the text. And I think that there's, you know, some difference of opinion about what you do when the text doesn't give you a clear answer, but not really much impetus to start any place else. And I completely agree. As an advocate, you want to tee it up, whether it's an agency case or simply a straight-up statutory interpretation case where there's not an agency at play, and say, gee, the language is completely clear, it fits with the structure of the statute, makes sense in terms of other analogous statutory regimes, and here's the answer. I also think it's interesting how some of the marquee cases are in large part statutory interpretation cases. So, for example, the health care case that the court's going to hear this term is about, I believe, 5 words in the statute regarding the way in which state exchanges are handled. And so it's a you know, very clear question of how you read the text in the statute, and obviously one that has real implications beyond that.
Yeah, I mean, I agree with all of that. I mean, obviously the individual justices have different individual approaches with respect to the weight they give to the different things you look at when you try to figure out a statute's meaning, the text, the structure, the purpose, the history, various presumptions, the practical consequences of different interpretations. They all give somewhat different weight to those things. But I will say that while there's, I think, a lot of stability now, and there's not going to be some abrupt shift, it really is quite remarkable if you're a reader of modern Supreme Court opinions to just go back a couple of decades and look at how the Burger Court read statutes. And Sean and Caitlin's point about the primacy of the text, you can go back and look at some major statutory cases from a few decades ago. And it's all a gestalt in which they're talking about, well, there's this sentence from the committee report, and the general purpose has been this, and the agencies have interpreted this way. And you can go through some major cases like Griggs versus Duke Power, and there can be little or no mention of the text of the statute, which would be unthinkable today. And that really is, I think, Justice Scalia was the earliest and still is the most ardent proponent of that view. And it is sometimes, I think, there's too much of a focus on its implications for legislative history because that ignores kind of the broader debate that I think goes on with the court. With respect to legislative history, I agree that it's still relevant because there's still justices who care about it and you make arguments to every justice. But it's almost funny how it's become marginalized in the way they will talk about it in the court. When you get a question from a justice about legislative history, he or she will almost always preface it, as Justice Breyer did when he asked me this once, well, some of us care about legislative history. Can you point me to any legislative history? And when they write opinions, I was reading one by Justice Sotomayor the other day, which was a statutory opinion, started with the text, and then said, and for those to whom legislative history is relevant, and then there was the paragraph. Why do they do that? Because if she didn't include that clause, there would be a separate concurrence in the judgment by Justice Scalia saying, I'm not going to join this opinion because of the legislative history. So there's a sense in which, yes, it's still there, but there's almost an apologetic way in which those justices who rely on it are willing to talk about it. The one other thing I would say, particularly if as students you're starting to think about what are these debates really about, there are a lot of ways to simplify these interpretive debates about statutes that will lose some of the nuance. And I'll give you one that loses some of the nuance, but it's one way to start thinking about what they're arguing about when Justice Scalia and Justice Breyer, let's say, are arguing about how you should go about interpreting statutes. And that is that one can choose to focus on, the product of the legislative process, which is the enactment, the text, the words. If you looked at that, what does that say? And that's what Justice Scalia urges, which is that that's what Congress voted on, that's the public act. All that stuff about committee reports and floor statements, that's all stuff about individual legislators or their staff. That's not the public act of enactment. We look at the text, what does it mean? And then you can alternatively look at the institution behind the text. What would Congress's purpose have been? What were they thinking about? Justice Breyer, I've seen him ask the question, if Congress had been aware, if the enacting Congress, the one that had enacted the statute, had been aware of what we are dealing with today, what would they have wanted? And he's asked in a way that's indicated that, at least in some of the cases, he regards that as the decisive question. Can we figure out what the Congress that wrote this statute would have wanted to do if it had known that this problem was coming up? And I think for Justice Scalia, that question would be completely irrelevant. So, as you read these decisions and think about these debates between text and history, one way to think about them is some people in the court see the relevant material as the output. And some of it see, at least in part, the relevant material being the process and the institution that produced it.
Just to pick up for a minute, if I can, on that last comment, I think that distinction that you're describing is particularly important because we have a lot of statutes that have been on the books for a long time, and so they may not have words or provisions that are really designed to address squarely circumstances today. And I think this is something in the greenhouse gas case that you argued last year. When you have a statute that was written in the early 1970s and it doesn't anticipate very squarely the reality of today and the way in which it might be used, what do you do, right? Do you, as Justice Breyer suggests, think about how would Congress deal with this as a practical matter? Or as Justice Scalia suggests, do you say the text is what must control the inquiry, regardless of whether or not that leaves us with a very useful fit for the circumstances today?
Although I would note that, still smarting a little bit from that one, that that Justice Scalia's reasoning in that this is a utility air regulatory group case was highly consequentialist, right? We had I think Peter would agree, a really strong plain language argument about any air pollutant. It was something the court had, in another context, already said, any air pollutant means greenhouse gases, because that's an air pollutant, and we were kind of hitting that very hard. The DC Circuit is, if anything, more fundamentalist in its textualism than the Supreme Court, perhaps, and they bought it. But Justice Scalia said, actually following the plain language in this context makes no sense. Everything breaks down. It leads to all these consequences that don't fit with other provisions of the statute, and clearly Congress didn't intend. So there's a way in which he didn't abandon his general theory about text, but the decision is clearly one where the outcome is driven by the sense that following the text in a rigid way leads to results. So interesting to think about that case and that result through the lens of the healthcare case this term, where there's a strong plain language argument for the challengers and I think, quite strong argument for the other side that if you right. are literalist with that language, everything breaks down, and Congress couldn't have possibly. And I noted that the SG's brief in the King case does cite UARG for this proposition that you have to have a kind of common sense check on where the plain language leads you. So we'll see.
Before we leave this topic entirely, some of these statutes are immensely complicated, and even if you spend your sort of life studying them, you still don't feel like you have a very good handle on what they actually say or mean or how they should be interpreted. What do you do to make something like this intelligible to justices who are definitely not experts in the area under the constraints that you face, which is that you don't have very much time for your argument and that the questions might take you in different places? So how do you make this intelligible and comprehensible to people who are highly trained lawyers, but lay people with respect to particular programs?
Well, it's funny. I mean, when you're talking about, let's say, the Supreme Court or the D.C. Circuit, where these cases are being litigated, these are enormously sophisticated and knowledgeable judges, some of whom have written not only opinions, but great works of scholarship in these areas, and they have a taste for complexity. And, these environmental cases can be awfully complex, but, ERISA is no walk in the park. Tax, bankruptcy. And I'm not actually disagreeing with the premise of the question, which is that however experienced you are with this stuff, every individual program has its detailed layers of complexity, which the lawyers dig deeply into, but the justices aren't going to, just because they don't have the time to focus at the level and they don't have the need. To me, I always rebel a little bit against the people who say you have to simplify it, because to me, if I were a judge or justice and I was hearing the advocate is simplifying it, I would say, don't simplify it. I can deal with complex things. I think what you need to be able to do is to figure out which of the many complex aspects of this thing are actually material to the decision. And once you've focused on that set of things, I think you can be as complex as you need to, because I think the court understands that. I think where people go astray is they start talking about so many different things about the program or the issue that are actually extraneous to the decision-making process that it becomes harder. And the other thing that people do, particularly in this area, is talk acronyms, which judges hate. I can't, I've seen judges yell at advocates for using too many acronyms, because the real thing you have to make sure of is that after you've dug deep into something and the vocabulary and the jargon is all second nature to you, forgetting that even to very knowledgeable people, the specific jargon and vocabulary is not. So part of it is a question of simplifying the language, and part of it is a question of isolating what you really need to talk about. But to me, I always worry, once you've done that, if you simplify the material, there's a real risk that they will know you're simplifying, and every advocate who simplifies doesn't simplify neutrally. If an advocate simplifies, he or she simplifies in a way that kind of filters out the bad stuff and highlights the good stuff, and they know that. So.
But I do think that it can be very helpful even when dealing with justices who have been looking at a particular regulatory scheme for decades, to take a paragraph or two in your brief, and I think actually the briefing is more important to this point than the argument is, and set the table, to talk for a paragraph or two about what the regulatory scheme does, what the component piece that you're looking at is, to peel that onion a little bit. I also think, and your point about the acronyms I think touches on this, it really puts a premium on pellucid writing. I mean, it is complicated enough, I think, not just in terms of the regulatory scheme, but sometimes in terms of the science even, that being able to talk about it in the brief in a very clear fashion so that you can be complex but accessible, I think that's the needle that you need to try to thread. And if you read briefs that, you know, either Sean or Peter write in the environmental cases, they're an easy read, even for someone who doesn't know anything about the particular piece of the Clean Air Act or what exactly the regulatory tools are that the agency is putting in place. And that's, I think, what's so helpful.
Yeah, I just add, I mean, this is what the idea of an appellate specialist, if there's a skill, part of it is that you don't know that much about any one area, you're not so deep in the weeds, and you're able to think of these poor judges and perhaps especially law clerks who are smart and know the tools of lawyering but don't know this regime, and kind of what do they need to know to even, you know, get in the particular space where the dispute is, and how can you say that quickly? And so that your ignorance of some of the detail can be a strength if you ask the right questions. And then the other thing I try to remember is just being a law clerk. I remember both on the DC Circuit and the Supreme Court, I remember like there were a few FERC cases and, you know, people were just afraid of them because of the complexity. And I remember trying to think as an advocate, that's the kind of people think this is really complicated. They want to avoid it. The Supreme Court, there's kind of, even though some of these regulatory cases are incredibly important in terms of all kinds of public values and money, there's a sense that the court, all things being equal, would rather not take some of these cases because they're really resource intensive and so forth. So you need to be really good at kind of whittling it down, particularly if you're trying to get them to take certiorari in a case that looks like, you know, a big, complicated muddle.
I will add one thing, just as a, you know, it's not my place to give career advice, but I once had, somebody came to me and said, oh, you know, I was just listening to a talk by Justice Alito, and he mentioned a case you argued, you know, this last term. And I got all excited, so what did he say? He said, well, he was explaining that everybody thinks that the Supreme Court is deciding, you know, is there a right to abortion? Should the schools be desegregated? And in fact, you know, he said, listen to some of the cases we actually had to decide this last term. And first and foremost in his list of understand how boring these cases are, was a case that I had argued about how you calculate the maximum compensation award under the Longshore Harbor Workers and Compensation Act. And, you know, I thought about that and I realized, you know, the truth is, I would so much rather, as a lawyer, argue that case than argue a case about the constitutionality of affirmative action in higher education. And why is that? Because there is zero chance, if I'm arguing about the constitutionality of affirmative action in higher education, that I can possibly introduce a thought in that discussion that those 9 people haven't already had and don't already know what they think about. I am just a prop for them to go back and forth with each other. But if it's the maximum compensation award under the Longshore Harbor and Workers' Compensation Act, well then if I really get into it and think about how I can position, you know, our side within the context of the broader framework of what legal principles these justices think should decide cases, and explain the scheme to them in a way that makes sense and that supports the position, I can actually make a difference in that case. Now, you will say But the difference I've made is in how you calculate the maximum compensation rate for a longshoreman, and that just doesn't move me, and I get that. And there can be great things about being involved in great causes, and I don't take anything away from that. But it is fun also sometimes to just have an opportunity where they are really listening to you and they don't bring to the argument really any preconceptions about how you calculate the maximum compensation rate.
And Peter, I think there can be collateral benefits as well. You mentioned the FERC cases on the D.C. Circuit. I actually met my husband while working as a law clerk on the D.C. Circuit on a FERC case. So it's not all as gloomy as it may seem.
So this question is directed to Sean and to Peter, and then I have a variant of that question directed to Caitlin. So for both of you, when you represent clients, you're typically representing a consortium of clients, either trade associations or individual groups or individual corporations. And I assume that these different clients come to the case with somewhat different positions, but there's a huge premium in coming to some common understanding, because it's very hard to argue that the statute has a very clear meaning when your own clients disagree on what the meaning is. So how do you deal with that?
Discussion. I would say the D.C. Circuit, where I practice a lot, actually helps because they have these rules designed to limit the burden on judges and the number of pages they have to read that basically force everyone who's on the same side. If you're amici curiae in support of one party, you sort of presumptively have to be on a single brief, or if you're interveners. And so if you're told the exit option isn't there, if you're going to be in the case, you have to be on the single brief. And I suppose you could drop footnotes saying, you know, NRDC doesn't agree with this, but that would be kind of unpleasant. And so there's a strong incentive and uncomfortable. And you know, usually by the time a case has gone through a complex administrative process and then a subset of issues are taken up in litigation, people have kind of hashed it out, and so it's often not that difficult. And then the groups that I work with, it's now been a number of years, and so I think there's a trust, and there's obviously a lot of, I'm sure this is true for other, you know, everyone who represents multiple parties, but there are hard questions where different lawyers would slice things differently, and you just have to talk those through. But, you know, the combination of deadlines and the common interest in winning makes it pretty easy to kind of work things through. There's an end point you have to reach. So.
Yeah, I agree with that. I mean, I think the easier situation is when you, the lawyer, have multiple clients. Because if they've all decided to be jointly represented by you, it means they repose a certain amount of trust in your judgment and strategic views, and they've also decided they can work together with each other. So, you know, you're probably in a, you know, easy starting place. The more complex and fraught situation is when you have multiple different parties represented by multiple different lawyers, because that additional layer of lawyers is what introduces a lot more need for discussion. Because, you know, there are a lot of different ways to write a brief, there are a lot of different ways to position a case, and different lawyers, in addition to sometimes having different actual goals, their clients may have different equities in the case, and they may want to emphasize different things because some types of relief help some and not the other. But even beyond that, you know, just different lawyers have different ideas of what the best strategic way to go is. And so it does require a lot of discussion. I will tell you that it is easier to be in that situation with 6 different parties and their law firms all aligned and having to work together than with 2. Because there's sort of a law of large numbers in statistics, which is that as the numbers get up, idiosyncrasies and deviations kind of wash out. And if there are 2 and you have different views, it's very hard to reconcile it. But if you have a bunch, then after discussion, you get to a point of consensus or near consensus, or somebody who has a different view yields to the collective judgment of the remainder. And you know, I haven't found a situation where that kind of collective discussion doesn't ultimately wind up not only with a product that everyone is happy enough with, even though it's a product that would be different from what anyone would have done individually, but I would say it results in a better product, because the one thing about those discussions is you cannot go into them with the idea, okay, this is just a problem to be managed, I have my views, how am I going to get them through this group? You have to go into them with the same understanding you want other people to go into them, which is, you know, actually everyone has some ideas here. They have certain rights because they're a party, but beyond that, there are smart people around this table in addition to me. and maybe they can make what I'm thinking better. And if you go into it with that attitude, and they do too, and you have enough time, things work themselves out.
A related question. I assume people like arguing Supreme Court cases, and if you have multiple lawyers, my guess is that there is some level of competition as to who's going to argue these cases. How do those issues get resolved?
Well, I will tell a tiny anecdote about a case that Peter and I were both involved in that was argued last term and is actually still going on back in the DC Circuit, called EME Homer, about interstate air pollution. So we had multiple parties. There was EPA, the author of the rule that was being challenged. There were downwind states that were receiving some protection from pollution under the rule, who were also parties. And then there were environmental groups. And so, and my people were the environmental groups, states obviously represented by AGs. And we petitioned for review in the Supreme Court, and EPA did, and the court granted both those petitions. And then it wasn't clear how they were going to do the argument. Obviously, the Solicitor General was going to have the lion's share of it. But there was some question whether maybe the states should argue, maybe we, because we were petitioners and had been in it, and there was a lot of question. Everybody, I think it was a good discussion because everybody wanted to win the case or do the best we could, and it was really harrowing. And part of it was for me, like, oh, I would be the one maybe who would do it, and so, you know, am I doing this because it's the best thing, or is it for me? And we finally came down to, you know what, it's a complicated case. The SG's office is great. Malcolm Stewart's a fantastic lawyer. We'll let it go. 30 minutes is just too much, so we came to a decision on that. And then the next day, the court issued an order adding, what, 15 minutes? So anyway, it was by then we'd closed it. But I mean, I think that's, you know, I think it's the kind of, I'm sure it's competitive and difficult. I remember a case when I was an associate, the American Booksellers, or no, ACLU versus Reno, the first internet indecency case. Where the American Civil Liberties Union and a coalition of private groups represented by Bruce Ennis of Jenner and Block both had, you know, good claims to argue for the petitioner, and the way they worked it out was a series of moot courts before a panel of 3, with one judge chosen by each party and a third, you know, chosen by the 2. So can you imagine 3 just really, really painful way to decide it? But I've never done that, and I would probably give in before agreeing to a procedure like that.
Did you ever do that, Peter?
No, I would absolutely give in before doing that. I'll tell you how I resolved. You know, there was one case. It was in the Fifth Circuit, and it was fascinating. Actually, it was a climate change case in which it was a class action by a putative class action on behalf of people who'd lost property in Hurricane Katrina. They sued like 100 different companies in the energy space, claiming that climate change, which had been contributed to by these companies, had intensified the force of Katrina and therefore created more property damage. The district court had dismissed it. We were in the Fifth Circuit. So there are tons of parties. And there are 2 of us who are happy to argue it and have taken a leading role in the briefing. One, a guy who had been, Dan Collins from Munger Tolles, who had been doing it for the oil companies, and I'd been doing it for the electric utilities. And I told my client, either is fine, I'm happy to do it, but Dan is terrific, and your interests will be fully protected. I think he said something similar to his client, and all the other parties were fine with it. So so we figured we should do something random. So Dan proposed that we each make a list of 5 elections for rock, paper, scissors, and FedEx them to each other. The idea being, you know, so like I would do rock, paper, paper, scissors, rock. He would do scissors, paper. And he explained to me that, you know, if the first one was a clear win, then that would be it. But with 5, since we were FedExing it, he was in California, I was in Washington, you know, we wouldn't have to keep on doing it because he calculated the probability that we'd go through all 5 without a victory as being some extremely small percentage. I then said, you know, let's see if we can save the FedEx costs. How about, you know, one of us pick odds, one of us picks evens, and we take the first decimal point of where the Dow Jones closes on Thursday afternoon. So, you know, the thing is, you can create mechanisms. Dan won. He picked odds. No, I picked evens, and it was a 0. And so I got to tell you, you can find ways to do this which are even more fun than the argument itself. And if you're creative and you do it in good spirit. I will say that, you know, it is, I mean, I was thinking about this when the court granted cert on the 4 marriage cases a few days ago, because, boy, you know, that's certainly going to be a context in which there are lots of people who've invested lots of themselves for years in developing arguments, who know the area well, who are highly skilled advocates. You know, there are any number of people who could do those arguments, and they're going to have, you know, challenging conversations because, as Sean said, I mean, there is also a layer of ambition, personal ambition, that can't be completely disentangled from this. You know, we all like what we do, and we all like to play as significant a role as we can in what we do. And so it can be a hard process. I will say that I think, you know, in some ways the most important attribute that can help this process is, you know, people have to choose somebody they trust. And by that I mean, you know, you have different companies or organizations, they have different lawyers. Whatever lawyer they pick, he or she only is going to have one set of actual clients. But unless the other clients feel that that person will treat them as if they were clients too, recognize that he or she is speaking for them, that they have responsibilities to them, even though none of the attorney-client, you know, formalities are actually there, and be honest and transparent, and say things like, look, if this issue comes up, this is how I would propose to answer it, generally speaking. Are you okay with that? And really think about what they're valuing in the litigation. If, you know, if you can develop a reputation for being someone that people trust to be an honest broker, it helps a lot, because in addition to all the things that people are thinking about how skilled is somebody, and do they know the material, and do they have, you know, the respect of the court, and whatever all things that lots of people have, you know, they're also thinking about, you know, when I pick up the phone and say, I really need to talk to you about this concern about how this argument is going to be done, will they talk to me meaningfully, or once I pick them, you know, am I just a problem to be dealt with?
And I think that's also very much aided by collegiality among the lawyers, right? So the client needs to trust whomever is going to do it, but also if you have your client and someone else is going to argue the case, to the extent you can pick up the phone after rock, paper, scissors has closed and be very, very direct about concerns, you know, issues that might come up, I think that that's helpful. I also think some cases lend themselves more naturally to one advocate or one party arguing as opposed to another. So, for example, the first case I argued in the Supreme Court was a constitutional challenge to laws that New York and a number of other states had about the interstate shipment of wine. And New York and other states imposed these very complicated regulatory regimes which ended up benefiting, as an economic matter, middlemen, essentially, who would receive wine and then, in turn, you know, send it on its way to whatever the retail liquor store was. So the court granted cert in the case, and there were some companion cases. New York had one of them, and the middlemen were also in the case as interveners, and they were represented by a friend and now partner of mine, Miguel Estrada, who at that point had argued, you know, a number of Supreme Court cases. He's a fabulous lawyer and very experienced in the Supreme Court. So if you were to just look at the two of us and say who should do it, I think you'd put your chits on him. But if you look at the question of whether the optics and the dynamics vis-a-vis the court will be better if the state is standing up defending its own statute, or the companies that are making some money off of that regime are standing up defending the statute, that answer is pretty clear too. And we all agreed that it made more sense for the state to do the defense in that case as opposed to the middleman. So I think sometimes it depends a little bit on the way that the case is teed up before the court.
Caitlin, when you were Solicitor General of New York State, I assume that figuring out what the interest of New York State was in a particular case wasn't always easy. There are many state agencies, there are many state political figures, and so on. What was the process of coming up with a position for New York State like?
Well, New York, I think, like many states, does have some complicated questions that arise, in part because you have an independently elected Attorney General and an independently elected governor. And the state agencies report to the governor, and the Attorney General does not. But the the agencies are the Attorney General's clients, right? So you have this sort of complicated crisscross of obligations and relationships. And so in a lot of cases, those interests were absolutely aligned. Sometimes there were cases where the Attorney General in his capacity as, the person who would bring affirmative litigation, who would go out on the plaintiff's side and sue, for example, to enforce the civil rights of New Yorkers or environmental protections, could come into conflict with lawsuits that the state agencies were facing as governments themselves. This came up most acutely with respect to the 11th Amendment, right? So there were a series of cases that the Supreme Court was hearing about when Congress could, to sort of simplify the question, when Congress could impose obligations that would lead to liability against the states. And if you are representing a state agency, the answer to that is pretty much always never, right? That you're going to say the 11th Amendment doesn't allow you to touch the states. On the other hand, if you are looking at whether or not, for example, under certain civil rights statutes, Congress can or did require that states be held liable under these provisions, the answer might be yes. And so those were cases where what the office would do would actually be to look in the pipeline at whether or not we had cases that were pending, because we couldn't really go into the Supreme Court and write a brief and say one thing and go into the Second Circuit and say exactly the opposite in defense of a client. I mean, even setting aside the question of our ethical obligations, that's a good recipe for someone sitting on the bench telling you that that does not make a lot of sense to her, right? So we really did try to be respectful of that, and sometimes at the end of the day there were cases where the Attorney General didn't get involved because of the liability facing state agencies, and sometimes where the state agencies would say, and their general counsel would say, it's okay. We feel like this is not something that we're particularly concerned about, but it was, a lot of back and forth.
Moving to a different Solicitor General, in federal regulatory cases, the Solicitor General has an outsized influence, as we already discussed. And in some cases, the Solicitor General will be on the same side as your client. In other cases, the Solicitor General will be on the opposite side as your client. So when you're on the same side as the Solicitor General, what do you do to affect the position of the Solicitor General, to coordinate the arguments? What do you do on the question of who argues and so on? So what's your relationship to the Office of the Solicitor General of the United States when you are on the same side of a Supreme Court matter?
Well, it's a wonderful office to work with, but it has its own protocols and procedures. So, for example, they're fine if you want to show them what you're writing and thinking, but they don't share drafts with you. That's an internal government thing. We often have good conversations with the people working as we sort of run by different theories, but there is a wall behind which you can't go with them, which is their own kind of internal discussions and deliberations, which are private government. But that still leaves lots of room for doing joint moot courts and things like that, where you are, if you're on the same side, you're talking collectively about how to make the argument so that you're not tripping over each other and saying things that undercut each other, and everyone understands it's in the joint interest to do that. But I would say that there's even a prior issue, which is the premise of the question is you're on the same side. It can take a real process to get there, and it can be a really open question whether you're going to be on the same side, and trying to get them on your side can be a major part of the advocacy effort. The process that Caitlin was describing in New York, where there can be multiple different interests in the government pulling in different directions, is very much at work in the federal government as well, and the Solicitor General and the Justice Department are there to try to resolve that. And just to give you a concrete example, a case we were all involved with, the Connecticut versus AEP case, which was a case in 2011 about whether there's a right for states and private organizations to go into court under a federal common law of nuisance theory and sue large emitters like utilities for the tort of contributing to climate change and thereby creating injury to the citizens of the state and to other interests. And the contemplation in that case had had it gone forward, would have been that the judge would hear evidence about the admissions and what would be reasonable level of admissions, and ultimately issue an injunction that would declare what would be a permissible level of admissions for the defendants to avoid unreasonable injury to the citizens of the plaintiff states. And real question, what position was the United States going to take in this case? And those of us on my side, I went and sought meetings with so many different government agencies who are clients of the United States, of the Justice Department. I talked to the Department of Transportation because, the transportation fleet has an interest in this. The Department of Commerce called up the Department of Defense because, boy, there are a lot of military installations which do a lot of emitting and could be subject to suits like this. And ultimately, it culminated in a huge meeting in the SG's office where their largest conference room was packed with all the different representatives of all the different agencies, not only sitting around the table, but then sitting around the perimeter. And the other side, I'm sure, had a similar meeting. And it's like a moot court because you sit there and you urge your position and everybody throws questions at you. The thing to remember is that they are not simply focused on, well, what is the right legal answer? That's absolutely part of what they're thinking about. But they're also asking the question, well, what's in the interests of the United States? And take a case like that, and there are a lot of different ways to think about the interests of the United States. I'm certain that EPA, sitting at that table, was not my friend. EPA, this was the beginning of this administration. They were seeking legislative amendments to the Clean Air Act in order to bring climate change explicitly within it. And I would think they would have felt that pressure on large sources of carbon from courts would have maybe helped the process of making a deal with those entities and getting something through Congress, and in general would advance the effort to establish more regulation of carbon emissions. On the other hand, it's fairly threatening to government regulatory agencies to have federal judges suddenly do in their courtrooms, through listening to expert witnesses and issuing injunctions, exactly what those agencies tend to do, which is do things like regulate the level of emissions. So the United States government had a significant interest on the other side as well, because saying there's this broad ability to go into court and have judges act in ways that seem quite parallel to federal regulators could potentially come back to bite federal regulators who would like the discretion to set their own regulations without having courts tell them it has to be something different. And then you had the complicating factor that one of the defendants in the case was the Tennessee Valley Authority, which is actually a client of the Department of Justice, and they were a defendant, so they were being sued. So, it's a process for the government to figure out, what its interest is. And so when you're in a meeting like this, you are talking not only about the legal merits, but how should the United States government think about what side it's on? And how can you help them see a path towards arguing something which is on your side, but nonetheless doesn't fly in the face of whatever aspect of the interests are at stake for them that are against you? And that's a very complex and interesting process.
And very rigorous, too. I think when you have those kinds of meetings, whether they're at that scale or smaller, you're in a room with people who are incredibly sophisticated, both the folks from the agencies, many of whom, as Peter is suggesting, will have a very firm view, one that they will have plainly shared with the SG's office, and lawyers in the Solicitor General's office who are about the most sophisticated lawyers in the country, but also who are very tapped into all of the interests that the constituent agencies around the table are bringing to bear. And so I think it's a process that doesn't get a whole lot of public light simply because it's a meeting, right? It's not a oral argument in a court, but one that I think is really quite substantial, and I find gives you some sense of how to frame the case, right? I mean, it's almost like a very early moot court, and some of the questions are ones that I've found end up pushing you to think very hard about the way in which you want to tee up your own case when you brief it, whether the U.S. ends up on your side or on the other side.
Yeah, I agree with all that, and I would say, one thing to notice about them, it's a very small office, 20-something attorneys, and they have this massive docket of merits cases, and then the cert work is huge, and so getting them, and so they just don't have a lot of time, and so sort of getting them at the time that they're up to speed, but before they've made a decision, whether it's which side to support when the court has called for the SG's views, or all kinds of situations where their position isn't well defined. That's a key part of it, is kind of knowing when to talk to them. I've just found them. They're incredibly sharp. They want to hear what your legal argument is. They don't seem to care much, who's a big company or who's an important group or a small group. They're very, very interested in the merits and very open. They're very quick at picking up arguments. So fun to work with. But yeah, they also have this kind of guarded internal process that's kind of their own.
I'll ask one last question, and I'll open it up to all of you. So could you tell us something about how you prepare for a Supreme Court oral argument, and how that might be different from how you prepare for an argument before a different appellate court?
Well, I've only had one, so I'll tell you, I think obviously lots of reading, lots of thinking, lots of trying to imagine difficult questions and reimagine what you've argued or should have argued in your briefs. And then I just generally, for all oral arguments, like to have a sort of moderate number of, I don't like having 8 or 10 moot courts. I think like maybe 2 or 3. I think getting the toughest minded other minds to engage with, people who are able to really, take your position that you've lovingly put together apart and ask questions that are, off the wall and, not ones that someone who knew a ton about the area would know. I don't know that I've gone through it enough to have a lot to say about the difference between, I think it's, it's obviously a larger panel, and you can get a wider range of questions than you might get from a DC circuit, but that's
my process is a little bit similar, I guess. I start by reading through the briefs and the cases and make sure that I think about the briefs in terms of what's the court seeing, and where do the issues join and where are there differences, understand what the basic case law framework is. I then sit down and make a couple of lists. One is I just make a list of every question I can think of. I mean like 200 or 300 or something like that, some of which may be very specific fact questions and some of which may be much broader questions about the law. And then I write down the answers, or I get somebody to help me answer them. And then I also figure out, what are the 6 or 10 or whatever number it is, really hard questions that I have a good sense I'm going to get asked, and what are my answers to those? And sometimes I really wordsmith that because I want to make sure that whatever the answer is flows well and doesn't inadvertently take me down a rabbit hole where I don't want to be. And I think in most cases there are usually just a couple of points that you really want to convey. You end up being asked so many questions in such a short window of time. It's a little bit like ping pong, except you're the ping pong ball, right? So figuring out what those 3 or 4 points are, whether they're addressing a weakness that you have or putting out an affirmative point, so that your answers to the to the court's questions can pivot to those, I think is really helpful. And then the last thing I do is I really try to make sure I have a practical sense of my case. So the last 2 cases I argued, for example, one was a car stop case. It was a criminal procedure case, and it had to do with the way in which identities are inputted into the computer in a police car. And I went on a ride-along with an NYPD officer and had him show me what he does with his computer when he stops someone, right? So that I could answer questions about the practical import with some sense of knowledge. The most recent case I argued, which was a couple months ago, was a case about the application of the Pregnancy Discrimination Act to lifting jobs in a UPS facility. And I went to a really big UPS processing facility, and I walked around to get a sense of what the actual facts in the case were about. And I find that to be helpful. I might not necessarily do that for a Court of Appeals argument, but in the Supreme Court, I think it can be pretty helpful.
Yeah, and something, I'd like to take a step back for a moment to, I was in the train coming up here this morning, and I was trying to get on a conference call. I was on the train, someone else was out of the country, and two people were at my office in D.C., and it couldn't work. It got screwed up, and one of the people who helped set it up was very apologetic. And I said, don't worry. I mean, I think it's magic that we could even think that we could have four of us in these different places have this conversation. I still don't understand how this works. And the fact that it breaks down 1 out of 100 times, it's still magic. I would say about oral argument, I mean, step back for a second. This is the one branch of government where, like, they're making the decision and you're there and you're interacting with them. I mean, you don't get in to see the president except in rare circumstances and with rare people in rare situations. With Congress, maybe you talk to a member or his or her staff, or you appear before a committee. In the judicial branch, there you are. It's the top of the branch. It's all 9 justices. They are not multitasking. For that hour, it's you and them. Yep. And they're asking, they're thinking through the case, and you're there, and then they're going to make a decision. So it's a tremendous way to participate in governmental decision-making, to be, in the moment there. And so, in terms of how that kind of affects preparation for argument, why is that relevant to this question? I mean, it's important to understand what that, the case has a long life, you've been briefing and all that. It's important to remember what that hour is about. And that hour is about these interactions. So, the most clueless thing I ever heard someone say about an argument, it wasn't a Supreme Court argument, it was a Court of Appeals argument. When he walked out, he said, I couldn't get through my argument. They kept interrupting me with questions. The questions are, you had your chance.
Right. Or I'll get to that.
Yeah,
I'll get to that.
I'll get to that.
Now, they're telling you what bothers them or troubles them, and
Right.
that is like gold. Right?
It's right. It's what you want, because you've had this chance to speak completely uninterruptedly, to build an argument in a linear way, logical point by logical point, summon all of your authorities for it, and that's the brief.
Yes.
Right? And now you get to see what they think of it, and what they liked and what they didn't like, and what confused them because you weren't clear enough, or your other side, they understood the other side's position differently than you did.
Or it's just a hard case.
Right. Yeah. And so the paradox, everything is about that interaction, at least for that purpose of the moment. And the paradox, I think, is that we all prepare maniacally for this. We read everything, we do, but the double-edged sword of that is that I've seen people prepare so much that they lose the flexibility and adaptability and ability to really listen to what's going on the argument and respond to it flexibly. No one at this table, but it's a common mistake. And, somebody, a statute of limitations issue is going to come up. And they have prepared and refined their answer to the statute of limitations question. And they know exactly what they're going to say. And then a judge, and this is more often in the lower court because the Supreme Court bar has become so experienced, but a judge starts asking a question about the statute of limitations. And you can see that the advocate, in his or her mind, they're already, as the judge is talking, are reaching in their mind for that mental file cabinet, here's my statute of limitations answer. And they may not have heard, but their co-counsel sitting at the table hears. The co-counsel always has such a better bead on the argument after it's over than the person who's in the moment. And they're not necessarily, they're just patiently waiting for the judge to finish his or her question so they can open up that folder and give their statute of limitations answer. But in fact, the judge said something which maybe creates an opening to take it in a different direction. And being really in the moment and able to listen and being completely prepared, but not letting that preparation make you so scripted that you can't engage in that interaction.
Because it's a conversation.
Right.
I think most effective, it's a conversation. And a conversation requires you to listen, and they will tell you if they are going to say anything at all, what it is going to shape their decision. Sometimes, I think more so in the Supreme Court than any other bench, they will also be talking to each other, sometimes through you, right? And that's, I think, a dynamic that is, I think, more true there than really in any other court I've argued in. But even still, they're telling you what's on their mind. And so the ability to talk and look relaxed and informed while you do it, I think that's why the preparation.
Do you, just a yes or no answer, do you take notes up to the podium?
Yes.
One page.
Not notes, but I take a binder of any material I might conceivably want to quote, like the statute, the regulation, and for reply, I will take notes. Because for rebuttal, I will be sitting there during the other side's argument, scratching out, 20 different points I might want to make. And then as the argument is going on, I'm crossing some out because, oh, I don't think that actually had traction, or, oh, one of the justices in his or her questions asked it. And then I've got 3 left. And that piece of paper I take up with me.
Me too.
Okay, we're open for questions. If you want to ask a question, maybe stand up, wait until you get a mic, because we're recording this and we want to hear your questions. And then the panelists can decide who wants to answer the question. There's no need for all 3 of you to answer every question. Yeah.
Hi, this is sort of a build off of one of the questions Dean Revesz asked before, but has it ever happened to you that you've argued a position in front of a court and then found yourself later in your career arguing sort of the other side of that position, and the court has been skeptical of that?
You mean me individually?
Yeah.
No, maybe at a level of real generality, but no, I haven't.
Yeah.
You guys?
I mean, so the point that Dean Revesz referred to from my EDF versus EPA case, that you can read the same term in a statute differently in different contexts. So that provision was deployed, and
Yeah.
there's a little mistake in its application, but it was used against me last term. So I had labored. There wasn't we weren't sort of making the. We weren't saying we're not being hypocritical. We said, it doesn't apply here. But I have had the experience of having a principle, a hard-won principle used, against one, and I think everybody has that at some point.
And in particular, if you're talking about something like statutory interpretation, right? I don't know if you've seen it, but there's this wonderful list of equal and opposite canons of statutory interpretation, right? I'm sure all of us have had the experience of using one and then using the other. You try not to do it in the same argument, but I think at that level for
and
sure.
any government lawyer will have had the experience of being, of having to defend the fact that the government's taking an opposite position, because governments do that.
Right. I mean, I think, when you're in the government, it's a big problem because the government is such a big place and people don't always, different offices are arguing different things, and there are mechanisms like the SG's office that try to create some degree of uniformity, but sometimes, when you're in the government, you meet yourself coming around the corner.
And sometimes administrations change views.
Right. And sometimes the court understands that entitles people to a certain leeway, and sometimes they don't.
Sometimes not so much.
They don't. I do think that when you're in private practice, it's different. I sometimes see lawyers in private practice who will try to zing the other side because that lawyer in another case representing another client argued something different. And that just seems silly to me. I mean, these aren't our positions. These are our clients' positions that we're arguing to the best of our ability in a professionally responsible way. So the fact that we argue for one client one thing and for another, who cares what Peter Keisler said? It's not what this is about. It's not my case. It's the party's case.
And I've never seen a judge bite at that either.
Right.
I think it falls flat.
Right. The one thing that people do try to do, which maybe is slightly more legitimate, but even then is, if it's a scholar who's arguing, and that scholar has written something, like, Larry Tribe gets this every time he argues a constitutional case because he's written a treatise on constitutional law, and the other side will look for it. I still think, at the end of the day, the court doesn't care, because the issue isn't whether Professor so-and-so is being consistent. Who cares? I mean, they have the arguments in front of them and will decide who's best. So I am perfectly comfortable with the need sometimes to, this client wanted me to do this, that client wanted me to do that. And usually the judges, again, because they're not personalizing it to me, they don't care what I once argued, because they don't even think of that old case as me. They think of it as the parties.
Michael. Oh, okay. Go ahead first, and then we'll.
So I had a question about mooting and preparation. Ma'am, you mentioned that when you were getting ready, you put together a list of 200 possible different questions with a few that you're focusing on. But at the same time, in the argument itself, you obviously can't have a whole source material of every possible question that you've put together and all of the wording and phrasing and such. So how, other than I guess just rote repetition and preparation and doing a lot of mooting beforehand, would you keep straight that many responses and, make sure that you maintain the fluidity that you need while at the same time having, good eloquent responses?
I think it's just a matter of becoming comfortable with the words coming out of your mouth. In I think a lot of cases, there are a couple of hard questions. And for me, these folks may be more fluid on their feet the first time out of the box. The first time I answer, I stammer a little bit. I try to redo it. I'm not quite sure if it's coming out the right way. And so the moods to me are so effective because once you hear it, you figure out how to make it sound hopefully even more effective.
Yeah, I think I would probably remember a few phrases that I think work, but not certainly memorize answers, and I don't think it would be optimal. But the preparation process is enough of an immersion that the ideas and answers are bouncing around in your head, whether you want them there or not. And so it's not hard to summon up. You can pretty quickly say, oh, this is, version, 3 of question 17. I recognize it. I've been thinking about it. Most of the time. Once in a while, there'll be something completely, off the charts that you never imagined, but that's pretty rare.
Right. And you don't want to get too rote because then it doesn't become the kind of conversation that Caitlin was talking about.
Michael?
So one recurrent locus at the intersection of regulatory policy and statutory interpretation is the extent to which agencies can or should rely on cost when the statute has been silent. And that's, that's American trucking, that's Entergy, that's the Mercury rule before the court now. It's lurking, or more than lurking, in the greenhouse gas cases. It's there all the time. And I was wondering if any of you or all of you would speculate or talk a little about the attitudes about cost and regulatory policy of the justices on the court now and how it affects their understandings of these statutes.
I think I'm working on the Mercury case for environmental groups, and I think I'm going to let the rest of the panel talk about it.
Well, it's interesting. I mean, the court has faced this question in a lot of different contexts. So, for example, in one case, the court said that in setting air quality standards, the statute doesn't permit EPA to take costs into account at all. And then in another case last year that many of us worked on, the court held that it was permissible when EPA is thinking about how to allocate emission reduction obligations among states that are sending pollution into other states to take cost into account in figuring out how to distribute those reductions among those different states. And now the case that Sean is working on now presents another variant on the question, which is, is the EPA required to consider cost in a different part of the statute? And, I think to me, the interesting question here is that I think a lot of people are influenced by whatever background presumption they take to the table. And that first case I mentioned, it's a case American Trucking versus Whitman, in which the court held that, and it was unanimous, that you don't consider cost. You cannot consider cost. EPA can't in deciding what level to set the air quality standard, because that should be a purely, under the statute, health-based standard. It was a really interesting divide in the court, and it shows some of these. We started out by talking about statutory interpretation. So Scalia writes for the whole court. And he really just focuses on the statutory text. Statutory text says you set these standards in order to establish a requisite margin of safety. That seems to be the measure by which EPA decides how much of a pollutant should be permitted to concentrate in the air. No reference to cost there. In the middle of a statute where in lots of other places, EPA is instructed that either must or can take costs into account. Purely textual analysis. Justice Breyer writes a concurrence. He doesn't join that opinion. He says, look, I agree in this instance, you shouldn't take cost, you can't take cost into account. But it is so sensible for agencies to take costs into account in regulating. How can you possibly, he said, normal cases, decide what the level of regulation would be unless you're weighing costs and benefit? And he comes at this from the background of somebody deeply steeped in regulatory economics. That he would apply a background presumption that unless the statute really clearly indicates otherwise, you always can take cost into account. And in that case, he went on to say that because of legislative history, among other things, that statute, he agreed, was the rare one in which the agency was prohibited from considering costs. But so, I mean, I think, the general issues we were talking about, which is how you at the beginning, which is how you understand the meaning of a statute and what weight you give to the words themselves or whatever background presumptions you or you believe Congress brings to the table. I mean, they're at play in all of these cases in really interesting ways, and the one that Sean is working on, and I'm not involved in that case, the one that Sean is working on this term is going to be another really interesting one.
And it goes back, right, decades. If you all have read TVA versus Hill in your class this semester, that's a case in large part which is about, do we care what the cost is, both the economic cost and also a little bit more broadly in terms of sunk cost of saving the snail darter is, and what does the ESA tell us about that, right? And so that debate, I think, it's not going away anytime soon. It's been around for a long time.
Other questions? So yeah.
I think a question we have, and I'm not sure if you have special insight into this, probably more than me, on at what point do the justices make up their mind? Is it when the issue, when cert is granted for some, or when the briefs are read? How much effect does oral argument have? I was wondering if you have a read on that, or if it's different for different justices from your perspective.
Yeah, I'm not sure I have any, they read, I'm sure some of them have very strong views from cert, this seems wrong, that's part of why we're granting cert, this is part of why. I think they all take the process really seriously of hearing oral argument. I'm sure none of them, have ever gone into an oral argument saying, there's no way, I'm already, I've written my opinion and it's a done deal. But I think, and then there are cases where it's really, a few cases where it's really in play, maybe until conference, and after conference there's back and forth, and I think that's a pretty small minority of cases. But, I mean, there's this debate about how important oral argument is. I think we would all say it's pretty important, and there are cases where it actually is likely to make a difference.
I think it's hard to win a close case without a strong brief, right? But I guess I share Sean's view. I mean, I come to oral argument with the assumption that the judges are there with open minds, and they may, having read through the papers, have a tentative view one way or the other. I think we would all expect that they do. But even when I've argued cases, none before the Supreme Court, but cases elsewhere where the bench is pretty quiet, I still don't walk away thinking, gee, that was a done deal, and I didn't really need, I could have mailed it in today. Maybe that's an optimistic view of the process, but that's definitely mine.
I will say, I think there are some cases where one side is dead on arrival. Yeah. Where you look at it and you say, the court granted to reverse. Let me just give you an example. I mean, there was a case a few years ago, AT&T versus FCC. There's an exemption from FOIA which says that if you request information that would, unreasonably, I don't know exact words, but infringe upon someone's personal privacy, that, the agency is required to withhold it. It's like Social Security numbers or investigatory files or things like that. And someone requested from the FCC information about an investigation into AT&T, and AT&T said that its personal privacy would be violated and pointed out, and the Third Circuit agreed, pointing out that the word person is defined in the general provisions of the code as to include a corporation. So a corporation can have personal privacy. And they granted cert, and you look at that and you said, I don't want to be the lawyer arguing that case for AT&T, and 9-0. But that's, but I agree with both Caitlin and Sean, which is that I feel that many cases are in play. It's how I make sense of the time that I invest in what I do as being worthwhile and having a potential to contribute to the outcome. And I will say that, having clerked, most years, as I understand it, and others who've clerked there may have shared this experience, there's at least one or two cases where someone loses the majority, yes, where the majority is assigned to Justice X. Justice X circulates an opinion. Justice Y circulates a dissent. And one or two justices who are the necessary margin say, upon reflection and upon reading the dissent, I'm persuaded the other way, and the dissent is rewritten to be a majority. And the majority is rewritten to be a dissent. And out in the public, you don't know, because when it's issued, well, there's a majority and there's a dissent. And you don't know that it went through that process. But things can be in play up to the very end.
I also
TVA
think,
versus Hill, right? Isn't
Yes.
that the archaeology of the opinion suggests, or maybe it was the Marshall Papers,
that there was a flip.
that there was a flip?
I also think that you can, in many cases, even if you're going to lose, and even if you walk in and you're pretty sure you're going to lose, you might care about how you're going to lose. That's particularly true if you care about the legal rule that's at play, not just, the win or loss in that discrete case. And there, I think oral argument can really have some effect. I think when you can credibly explain to a court why it is that losing this way is going to have all kinds of untoward consequences, but losing that way, after you've, of course, staunchly defended your position, I think it can be something that matters there, too.
Right. Justice Sotomayor asked Solicitor General Verrilli,
Yes.
how would you like, if we're going to rule against you, how
would you
should we
like to
do
lose?
it? Yeah.
And he lost, in the way he wanted.
That's an important question to have the opportunity to
It's not usually that
answer.
out in the open,
Yeah.
but, yeah.
Okay.
Okay, I know many of you have 2 o'clock classes. We've had a terrific panel. We should give them a big round of applause. Thank you so much.